Welcome to The Explainer. Today, we're jumping right into a pretty classic neighborhood dispute, one that actually spiraled into a full-blown court battle. We're talking about one homeowner versus his entire homeowners association, and believe it or not, the whole thing started with a really simple question.
So, what do you do when you think your HOA is breaking its own rules? I mean, really breaking them. To push through some major changes you absolutely do not agree with? Well, that's the exact spot homeowner Thomas Satterlee found himself in. And he did something most of us would only think about. He actually took them to court.
All right, so let's get into it. First up, we really need to understand Mr. Satterlee's side of the story. Okay, so this whole thing kicked off back in January 2015. The HOA board decided it was time for a complete overhaul of the community's rules. They put it to a vote, and yeah, it passed. But for some of the residents, something about the whole thing just felt off.
And this is where Mr. Satterlee comes in. His main argument was super simple. The HOA broke its own rule book. He said the board never gave people a clear side-by-side look at the old rules versus the new ones. It was like they were asking homeowners to just vote blind.
And when he testified, Mr. Satterlee, he did not mince words. He flat out said he believed the board was rushing this whole thing on purpose. Not to make the community better, but just to grab more control for themselves.
So this whole messy dispute really boils down to one central mystery. Which set of rules was the real one, the one that was actually legally binding?
You see, the heart of this entire conflict is a really confusing history. You've got two different governing documents, right, created just a couple of years apart. And here's the kicker. Each one had totally different instructions for how you're supposed to change the rules.
And this is where it all comes to a head. The HOA says, hey, we followed the 1990 rule. Simple majority vote, done. But Mr. Satterlee comes back and says, no. You ignored the 1992 update. And that one had a much stricter requirement. You had to show a side-by-side comparison of the changes on the ballot. And that just didn't happen.
So which one was it? Which document was the real one? That question, that's the key to this whole legal puzzle. Literally everything hinged on whether that 1992 update was actually legit.
Okay, so let's fast forward to the hearing itself. Both sides are in court ready to present their evidence to the judge. Let's see how it plays out.
Mr. Satterlee's logic was actually pretty straightforward. He basically argued, look, this 1992 update was officially recorded with the county. He testified that, and I'm quoting here, no prudent man would go through all that trouble unless it had been properly approved by the homeowners way back when. For him, that official stamp on the document was all the proof he needed.
And you know, it wasn't just him. Mr. Satterlee wasn't alone in feeling this way. Other homeowners actually testified for him, describing this really rushed process, where the board was basically shutting down any attempt to ask questions or have a real discussion.
But the HOA came back with a pretty powerful counterargument. Their board secretary got up and testified that she'd searched all the records, and she could find zero evidence. We're talking no meeting minutes, no certifications, not a single thing to prove that 1992 document was ever actually approved. From their point of view, it was just a piece of paper with no real authority.
So what do you do with that? You've got conflicting stories, a super questionable document. How in the world does a judge figure out who's right? Well, it all comes down to this really important legal concept, the burden of proof.
Think about it, right? In any court case, somebody has to be responsible for providing the evidence. You can't just walk in and make a claim. You've got to be able to back it up with facts.
And this is the exact point where the whole case pivots. It wasn't the HOA's job to prove the 1992 document was a fake. Nope, because Mr. Satterlee was the one making the claim. It was his job to prove it was real. The burden of proof was all on him.
And there's a specific standard he had to meet. We're not talking about a criminal trial here, so it's not beyond a reasonable doubt. It's a lower bar called preponderance of the evidence. All he had to do was show that his version of the story was more likely true than not. He just needed to tip the scales of probability even just a tiny bit in his favor.
So the big question is, did he have what it took? Could Mr. Satterlee convince the judge his version of events was more likely true?
0. That's it. That's the number of documents, the number of meeting minutes, the number of certifications Mr. Satterlee was able to find to prove the 1992 update was ever actually voted on. A big, fat 0.
And with that, the judge's conclusion was pretty clear-cut. Without any hard evidence, Mr. Satterlee's entire case was built on an assumption, not on actual facts. The judge found that the 1990 rules were the only ones that were verifiably approved, and since the HOA followed those 1990 rules for the 2015 vote, well, they hadn't actually done anything wrong.
So the final verdict came down. The judge ruled completely in favor of the Homeowners Association. Mr. Satterlee's petition was dismissed, and those new rules from 2015, they were allowed to stand.
You know, when you think about it, this entire case, all the lawyers, all the testimony, it all hinged on a single missing piece of paper from 1992. It's a pretty powerful reminder, right? In any kind of community governance, good record keeping and following the proper procedure, they aren't just boring details. Sometimes they can be literally everything.